Okay, great. Um, so let me just click continue. All right, here we go. So force majeure, what is it? Why have it? What does it cover? What does it not cover? And most importantly, for all of us practitioners, how does it help clients? If we can't use it to help clients, what's the point of it? Here we go. Force majeure, a force majeure clause. It's actually French for superior force. A lot of people think it's Latin or something for act of God, but it's actually French. Is a contract provision that relieves the parties from performing their obligations in certain situations. And those are situations that you spell out. It is frequently applied to what we call acts of God, which are really events in nature that are neither anticipated nor controllable. It can apply to war, acts of terrorism, epidemics, strikes, governmental action, accidents, and as you'll see, it can apply to very narrowly tailored individual incidents that could frustrate the purpose of a contract. In terms of burden in using a force majeure clause in a litigation context, the burden of demonstrating force majeure is on the party seeking to have its performance excused. So if you're trying to not have to go through with your obligations on a contract based on the force majeure clause, that's going to be your burden to prove. You have to demonstrate efforts to perform despite it. There's contract law is what it is. You are expected to perform the obligations you've agreed to in exchange for consideration. So there are certain things that you're going to have to demonstrate. And as some of the examples I go through will demonstrate, it has to be real. You can't use a force majeure clause just to get out of something that you don't like anymore. You made a bad contract. We're free to make bad contracts, but there's a reason you put your name on the dotted line. So I pulled this quote from Western District case here, but it's pretty applicable to all of the instances I'll be describing. We're mostly going to be focusing on New York law here because generally we're New York practitioners, and how New York courts interpret force majeure clauses is going to be most relevant to us. Okay, so first question is, why have a force majeure clause? Number one is the uncertainties of life, to protect your client, limit the damages when something occurs that is beyond the control of the contracting parties. That's essentially the essence and the importance of a force majeure clause. So the parties in negotiating a contract are the ones who determine the scope of a force majeure clause, just like they would determine the scope of their contract or the terms of their contract. So, what kind of uncontrollable events would frustrate my client's ability to perform their obligations under this contract? So you want to look at what the contract is seeking to do. There are issues you can raise in certain events without a force majeure clause. You can try to claim impossibility of performance, or what you've agreed to is now illegal. But with a force majeure clause in the contract, you have a chance where you can spell out what would be, completely frustrating to the purpose of the contract. So if you can spell it out in the contract, why not do it? It would be impossible to perform if X happens. So, if I cannot obtain, let's say, Canadian maple syrup needed to complete my contract with you, because the US has placed a trade embargo on Canada, and I've agreed that I will only get you the finest Canadian maple syrup. A force majeure clause covering unanticipated government action may be great there, maybe help excuse your performance, so you don't have to be sued for breach of contract. Other things may apply there, but that's kind of an example of where you wouldn't anticipate that the United States government would issue a trade embargo on one of our closest trade partners, right? So when you entered into a contract to provide Canadian maple syrup, you probably thought this was all good, but it's all good until it's not. And a force majeure clause for an unanticipated government action would be pretty salient there. Moving on to the next slide. So what does it cover? It covers, just like a contract, what the parties agree it will cover. Basic tenets of contract law apply. We're going to assume, especially if, in a commercial context, that there are two sophisticated parties agreeing on what it is their obligations will be. Force majeure clause, just like the contract, should be ambiguity free. There are some caveats to that because you're not Nostradamus. You're not being expected to predict every disaster event that's ever going to happen and when it's going to happen and how it's going to affect you. That's not the kind of the narrow view we're going to take of it, because that would be impossible. It would frustrate the purpose of the clause, because nobody can predict these kinds of things. That's the whole point. You can predict what kinds of things would frustrate your business, but you're not expected to, give date, time of the hurricane that's going to, totally screw up your contract. So same principle applies here to as to basic contract law applies to the force majeure clause. Interpretation is to be narrowly construed, but not to the point of, like I said, date, time, location of a hurricane. And only the force majeure clause specifically includes the event that actually prevents a party's performance. Will that party be excused? The case law makes it sound like you need the date, time, and location of the disaster event, but that doesn't mean that's, in my interpretation, that's not what it means, because you can't predict the disaster. You can list categories of force majeure events, and that should be sufficient. You can even put in a catch-all. I don't think that the catch-all is as enforceable as if you listed out all the different force majeure events that would completely frustrate your purpose. But you don't have, like I said, you don't have to be Nostradamus and predict a Canadian trade embargo. So what does it not cover? Again, now it is narrowly construed, and the case law says this. So you're not going to get by with the catch-all with events that are frustrating but not contemplated in the contract. By frustrating, I mean the layman's term frustrating, not necessarily the legal definition of frustrating, which is different. Impracticality or unanticipated difficulty, that doesn't necessarily excuse performance. Adverse economic conditions. We entered into a contract during a period of economic expansion, and then a recession hits. We could be in a very similar situation right now. That is not sufficient to relieve you of your obligations. We know that markets fluctuate. We know that the price of goods goes up and down. If you agree to buy barrels of gasoline for $3.50 a gallon for 10 years, right now, you're not very happy with that contract. Gas is way cheaper than that. So, but you made the contract when you did, and you made it for a purpose. That purpose has not been frustrated. That's not a force majeure. That's market forces. Markets change, commodities fluctuate. It is what it is. We know that when we enter into contracts. Sophisticated business entities know that, laymen know that prices of things change. And just because they change, it isn't a frustrating force majeure type event. You can have contracts without force majeure clauses, and you can still try to claim those other things I talked about earlier, impossibility, illegality of performance. There could be, mitigation there. But if you have a chance to spell out what kinds of things would excuse performance, why not do it? However, there's also the kind of contract where you don't think that any disaster, pandemic, anything like that should affect your contract. You can explicitly put in the contract that force majeure is not a defense for either party, that it has to be performed. And you can do that. You're free to contract to do that. I don't see that very often, but you're free to do it. So how does this help clients? Especially, if you represent small businesses, things like that, they operate on a month-to-month basis. A bad 3 months could be catastrophic. So adding a defense to the uncontrollable. Parties to a contract have obligations, consideration, and a force majeure clause can actually protect both sides of the contract. Having relief from the obligations in a large contract, which you cannot perform, can save your business. Devastating loss of revenue, breach of contract lawsuit with a high probability of losing, bankruptcy, other forms of turnaround. This can provide your clients peace of mind. So if they enter into a 10-year commercial lease, they're not necessarily going to be forced to be bound by that. Commercial tenants, you're on the hook for the entire amount of rent for the term of the lease. There's no duty to mitigate on the part of the landlord. So, if you can build in some sort of force majeure clause into your lease, for example, you could be in a much better situation when you come out of, let's say, a pandemic than if you don't have those kinds of things in place. So you can provide your client with peace of mind because, the unexpected does happen. We know that, or else, we wouldn't be having this discussion. And a lot of, we wouldn't have the amount of work that we have because when the unexpected does happen, people need help. And these kinds of clauses can help mitigate a lot of the dangers of navigating the business world. So we're going to turn to drafting force majeure clause. So drafting the force majeure clause. Keep in mind the following. The purpose of a force majeure clause is to limit damages in a case where the reasonable expectations of the parties and the performance of the contract have been frustrated beyond the control of the parties. So you shouldn't go into drafting a force majeure clause thinking, here's something I can use to get out of the contract later. This is, that's not any way to do business, first of all. But you should be looking to perform this contract, and everybody wins that way, right? But you should plan for the unexpected. Need to think of what kinds of things would be frustrating to the business, meaning it would make it impracticable, impossible to do. It would be devastating. Those are the kinds of things, unexpected things that you want to build into your force majeure clause. And then again, I'm talking about the definition of frustrating, not things that are merely irksome, meaning annoying to you, that the cost of gas has gone way down and it is frustrating you on a layman's level, but it's not frustrating the contract. It just means you're not making the profit margin. Let's say you're not making the profit margins that you thought you were going to, or something to that effect. That is irksome. It is not legally frustrating. So let's take a look at a few practical applications here. So let's look at a sample clause, which I will read, and I'll try to emphasize parts of it that I think are important with the inflection in my tone. If either party, here's the sample clause from one of the seminal cases in the New York State law on force majeure. So if either party to this lease shall be delayed or prevented from the performance of any obligation through no fault of their own by reason of labor disputes, inability to procure materials, failure of utility service, restrictive government laws or regulations, riots, insurrection, war, adverse weather, acts of God, or other similar causes beyond the control of such party, the performance of such obligation shall be excused for the period of delay. So I think that there are a number of significant portions to this sample clause. Some of them I think may be overbroad and may not actually constitute unforeseen actions. Adverse weather, that is an extreme, that's extremely broad. I mean, if you don't have an umbrella, rain is adverse weather. But if you do have an umbrella, it's just maybe a minor annoyance. And restrictive government laws, there are lots of restrictive government laws. But if a government law comes into play after you enter the contract that was not anticipated, that's more reasonable. So the sample clause here appears to be a commercial lease, again, where there's no duty to mitigate damages. So you can be on the hook for the entire contract. You break the lease and you're on for the full amount. So, those are important things to consider because, owing, let's say you're 1 year into a 10-year lease, if you owe the 10-year amount of the lease, that could be a torpedo to your entire business if you're not able to pay it and if you breach the lease. So one thing that's in here, though, is clever language, which is where it says for the period of delay. So it's not saying let's just throw out the baby with the bathwater. If we have a period where one of these force majeure events are occurring, we don't have to cancel the whole contract. We can't, we don't just cut bait and go our separate ways. It's for the period of the delay. So but that doesn't necessarily relieve the obligation to pay rent. So that's one important thing with these kinds of leases. So it is important in these clauses to list what obligations, in my opinion, which obligations you're going to be relieved from performing. Because if it just says obligations, does that mean all the obligations in the contract? There are certain obligations in a lease that you can't forego because it could potentially be illegal for you to do that. So I think it would be important to list what obligations are suspended, because it appears in certain case law that it doesn't necessarily excuse the payment of rent, even a clause like this. It may excuse other obligations, like the ability to let the landlord into the premises or something like that. But landlords have to pay their mortgage oftentimes, and so usually they pay that mortgage with the rent or a portion of the rent that they receive from the tenant. So this isn't just greedy landlords trying to collect rent from these tenants who need help. If a landlord defaults on his mortgage because a renter defaults on their lease, it's a chain reaction that can result in a foreclosure of the property. So it's important to build in what kinds of events. And here, which they did build in, was for the period of delay. I might even put a limitation on the period of delay, because if the period of delay is forever, then, because that could be a period, it doesn't really serve any purpose. So, you should build in some sort of rent abatement if that's what you intend, instead of just saying obligations. But you would hope, and especially in a climate like this, where people would be willing to work with one another. And if they did that, there would be less work for us if everyone was really nice and worked with each other. But so be it. Another thing that's important is that if you're going to have some sort of rent abatement clause, especially in a commercial lease where there is a mortgage on the property, you might have to get the lender to approve it, and a lender might not approve that because then they think that that'll diminish their ability to get paid, and it could be seen as them acquiescing to agree to not get paid for a period of time. So, contracts all the way up and down the line, like in a commercial lease like this, you need to spell it out, in my opinion. And, I think that we'll see more detailed obligation lists and periods of time and events that would qualify as force majeure. I think we'll see more careful drafting going forward based on what we're dealing with now, where a lot of small businesses are facing this rent issue, and a lot of commercial landlords are facing their mortgage issue on, for exactly these reasons. So I think that it'll be an exciting time for these kinds of clauses, whether or not they're ever, used again. It's been a real world application of something that we thought was kind of, it was a little theoretical for a little while, especially since I've been in practice. There hasn't been these types of events, until now, so we'll see what happens.
Eric, one of the questions we had come up in the chat room was how force majeure clauses might be looked at from an employee perspective. So what do you think in terms of that, and what should people be looking out for?
And you mean an employee in that they have employment contract? I assume that's what they mean. So
I think so.
If an employment contract, I think that's the same thing that I was saying before. So if you're drafting an employment contract and you agree to pay someone $10,000 a month, and in exchange they work and they can only be fired for a cause, they're not an at-will employee, but employment contracts, they could include, and oftentimes they do include, the ability to furlough an employee, where maybe they'll still get their health insurance, but we can't afford to pay you right now because there's this act of God occurring. So that's one place where it could apply, is that you could build that in there, especially that's more of an employer benefit, as opposed to an employee. You wouldn't necessarily want to agree that you wouldn't get paid in the event of some sort of disaster, because then you can't meet all your personal obligations necessarily. So, that could be something that could be negotiated, that in the event of a force majeure, you agree to take 75% of your salary. You'll only be required to work 30 hours a week remotely. I think that it's good if you can spell those kinds of things out. So, for example, during this kind of pandemic, if you had that kind of clause, you would have a certain amount of security, knowing that, no, I'm not going to be able to make my full salary during this pandemic, which is unfortunate, but you still have employment. And it says it in the contract. that even if all the worst things that you can anticipate happen, you still have, you know, a certain amount of salary. And now maybe you have an extra 10 hours a week, and you're like me, where you have children, you have a child, and that child is now home with you, and you have that 10 hours a week to meet all these new obligations that you've never had before. So I think that it kind of cuts both ways. But I think that just like it's kind of a very lawyerly answer is that you can put it in the contract, and you should. Especially now that we've faced we're amidst what I consider a force majeure, as long as you have the right terminology in your contract. You know, I think it's going to open people's eyes to the need to prepare for these kinds of things, even with at-will employees. You know, do you want to put them on a contract maybe that spells out exactly what their rights and obligations are? Do you want to put those rights and obligations in a handbook if you want to maintain them as a at-will employee that lets them know what their rights are going to be in terms of layoffs, furloughs? You know, I encourage businesses to put those kinds of things in contracts or handbooks. The less ambiguity there is, I would love if you ever got sued or you get brought before the EEOC or something like that. And I have Exhibit A is spelled out exactly what's happening here, and it's happening to every employee. There's no discrimination. There's no breach of contract. You know, that's great. I call those my Exhibit A's, where you have a document that spells out exactly what the rights are. And if you followed that and it's not otherwise unlawful, you know, you're in good shape. And that's a fun case to work on, because you're pretty sure you're going to win as long as, you know, you have a judge who reads the papers and things like that. So looking at analysis and interpretation. I know I speak kind of fast. If you miss anything, please write it in the chat box, and I'll be happy to reiterate. I'll also give my email at the end. Sometimes I'm more coherent in writing than I am in speaking. So I'm happy to send any of these musings that I have to you. Some of the terms of the force majeure clause that we just looked at, I'll buzz back to it because I talked for a while. Here's the force majeure clause from the Kelkim Corp case. So I pulled out a couple terms from that, including, you know, war, government regulations, adverse weather, which I mentioned, which I don't love that one. But, you know, because how hard is it to write out, you know, if you live in what we call flyover country in the United States, maybe you really want to put in something about tornadoes because you live in Tornado Alley. Could you argue that they're not anticipated? I think that you might have a little bit of an argument there. But here on the East Coast, for example, we may be worried about floods, or you know, if you live up on Lake Ontario, all of a sudden Lake Ontario is flooding, and you know, there's been quite a bit of litigation coming out of that. So those are the kinds of things, you know, anticipate. You can frame it for where you live, for the things that you might actually encounter. So, you know, that's where the narrowly tailoring comes in. You know, adverse weather. I don't like that clause. But anyway, there's also catch-alls. You know, other or similar circumstances beyond the control of such party. So let's say you have war, but you don't have a terrorist attack in your force majeure clause. You could say, you know, was it a war started by a non-state actor against you? You know, a 9/11 type event. You know, Al-Qaeda was not a country, they're a non-state actor. Does that still count as war? I think that there the catch-all might save you, or other similar causes beyond the control of such party. Obviously, what a terrorist group does is beyond your control. Hopefully it's beyond your control. But you know, that kind of thing could if you have war in conjunction with similar causes, I think that would save you. All right, let's turn to my next slide here. So war, what is it good for? Absolutely nothing. No, it's not good for absolutely nothing. It's good for relieving contractual obligations. That's my joke of the presentation. So there are, however, practical limitations. No, none of us want war unless you work for some sort of military contractor, but generally war is bad, right? So, and you don't expect war. We don't want war. So you got to look to the terms of what actually constitutes a war, what you know, what kind of war could be, can a war be anticipated when you're negotiating a contract? I think the answer is yes. Things like the war on terror. It's been ongoing since 2001. I mentioned the September 11th attacks. But the war on terror has been going on since 2001. The war on drugs has been going on since the 80s, maybe earlier. And the war on poverty has been going on, for the better part of 60 years. So, all these things, we call them, our government calls them wars. So, it's their, that's really their bailiwick is war. So if they're the ones who call this a war, so the president has called this pandemic, a war against an invisible enemy. He's labeled it a war. Do I think that a pandemic would fall under the war? No, I don't think so. But there are other terminologies that you can use to cover what's going on right now. So, for example, the war on terror has been ongoing since 2001. It doesn't necessarily excuse you from a contractual performance on a commercial lease you signed last week. You know that the war on terror has been going on. Everyone knows that. You can't sign it thinking, but I've got this ace in the hole that there's been a war on terror going on for the last 20 years. So I can, if this becomes untenable for me, I can use the war on terror to get out of performance. That's not going to fly. No way. So, you know that these things are going on when you enter into a contract. The war on terror hasn't stopped, millions of contracts from being executed since and performed. So you're not unique. It doesn't affect you any differently than anyone else. So, that's what we're looking at. However, a war breaks out during the performance of a contract. That may well excuse your performance. Wars affect, let's use the example of World War II, where the entire country, kind of shifts into a mode where everyone's planning victory gardens and the food is being shipped to our soldiers, and there's rationing, and we have to use all of our raw materials to build tanks to fight the Nazis and the Japanese, and it changes everything. So there, I think that that's an entire reshaping of your economy for 5 years. So that would be entirely different. So another thing that's in there is government regulations. So what is the effect of the legislation? There could be legislation that makes what you do way more difficult. Let's say you're a natural gas extractor, and you get some of your natural gas through normal channels, and you get some of your natural gas through the use of hydraulic fracturing. Let's say the state of New York bans, or they just ban it in the spot where you do it. Does that make the contract more difficult to fulfill, or does it make it impossible? So those are the kinds of things you got to think about. If you know that there's a draft bill heading towards Governor Cuomo's desk, and you enter into a contract to conduct hydraulic fracturing, and it could be a matter of days before he signs a ban into law, you can't check your common sense at the door. There are certain things that sophisticated business entities, especially in the oil and natural gas realm, that they're aware of, and their terminology is very specific. I think that actually might be a slide in here, because the leases that they execute are very specific, and they have, they're very unique in that there are ways to, that courts look to interpret those contracts. So another thing is the timing of the legislation. Did we know this was coming? Was the legislation in effect at the time of contracting? These are all the things that courts are going to look at if you try to assert that government regulations are the reason, and it's listed in your force majeure clause, that you can't continue performing.
Eric, we had a couple questions come in related to this. So do you really need language related to government regulations preventing contract fulfillment, and wouldn't that fulfillment be impossibility by default? And then additionally, and I think this goes to your last segment of bullets, do present conditions during the formation of the contract exclude future claims of force majeure?
Okay, with regard to, there is going to be some overlap between impossibility and what you put in a force majeure. But impossibility, you then have to prove it. If you put these anticipated, some of them can be very general categories, in the contract itself, I think that then you're talking about what's in the four corners of the contract instead of trying to argue impossibility to a court. And you're arguing impossibility after you've been sued for breach of contract. So, and again, you could be arguing force majeure after you've been sued for breach of contract. So, there is definitely some overlap, and impossibility and illegality are going to have significant overlap with force majeure. But this is a way that you can put a clause already in the contract that, government regulations, it doesn't necessarily make what you do entirely illegal. But if the only place that natural gas exists is, let's say they ban it within 10 miles of all New York waterways. Waterways are extremely broadly defined, and you can no longer effectively extract natural gas. If you build that in, while it's not necessarily illegal to extract natural gas in New York, if you build in some specifics about if there is a ban put in place for X, Y, and Z, that it would frustrate the purpose of our contract. Why not spell it out? And that way you put the other party on notice that if this happens, I'm not going to be able to perform the contract. I think that that's a place where you can kind of eliminate some of the uncertainty that you would need to. You plan for the uncertain as opposed to invoking an impossibility defense at once the case gets to court. And what was the second question? I'm sorry, Megan.
And we actually had another question come in related to this. So it was, so present conditions during the formation of the contract exclude future claims of force majeure. And then similarly, we had a question come in. It said, what if a war has been going on and you know about it when you first form the contract, but then it changes or expands and does end up affecting you? Does including a generic war clause work?
I think that it might, in terms of the war clause. Let's say we have advisors in Southeast Asia, and there's technically a conflict going on, but then we send over tens of thousands of troops after you've entered into the contract. The United States has military presence lots of places, but if we send 100,000 soldiers to Vietnam, for example, and you do a ton of business with Vietnam, and now there's a full-blown war going on, I think that would be a difference for sure. And you could put in war, escalation of warlike conflicts. I think that war plus that catch-all would probably get you there. And what was the first question again? I'm sorry.
Nope, it was similar. So present conditions during the formation
Sure.
of the contract exclude future claims, force majeure.
I actually disagree with that premise. If you enter into a contract now to perform something over the next 10 years, I think that you can still plan for a force majeure event of a pandemic. Let's say we get COVID-20. Not that they go sequentially, that's a false narrative, I think. But let's say we get another pandemic 3 years from now. Oh, but when you entered into the contract, we were in a pandemic. That doesn't mean that we have a reasonable expectation that pandemics are going to occur constantly now. I don't think there's any evidence of that. So I think that if you enter into a contract now, I think you should still have, especially now, have a force majeure clause that says if we get hit by another pandemic, that there is some, if it affects your business in some meaningful way, that there is a force majeure provision for an epidemic or a pandemic or a global illness. All right. So we're going to do a hypothetical. Company A enters into a contract with Company B to construct small aircraft for Company A in exchange for money over a 10-year period. 2 years into this contract, it's going great. Unfortunately, war breaks out with Canada. The president uses the Defense Production Act, which we've heard a lot about lately. Maybe it was about 2 weeks ago. There was a lot of questions about why it wasn't being invoked, or it was being invoked but not used. But anyway, I've used it here in my hypothetical because I think it's an interesting power of the executive. But uses the Defense Production Act to order a great company like Company B to shift all of its production to producing warplanes to fight the Canadians. So Company B can no longer meet its obligations to Company A. So what portions of the force majeure clause, similar to the example that we looked at, could potentially apply here? So you probably looking at war, and you're also looking at government regulation. So we know that the Defense Production Act exists, but do we anticipate that it's going to be invoked and applied to your company? I think that you could make a credible argument that you did not anticipate that war would break out with Canada. If you have war in your clause there, But you also probably don't anticipate that the government is going to order you to stop doing what you're doing and start making warplanes, because we need them for the national war effort against the Canadians. So, I think that there would be a number of clauses there that could allow you to escape your obligations. And by escape, I don't mean in terms of anything nefarious, but you wouldn't be able to meet them because the government has used a legitimate power to order you to do something different. So, and I've added another caveat here. So could there be an additional fact? Company A is an Ottawa-based military contractor. So you obviously can't be selling planes to the Canadians if we're at war with the Canadians. I think that's common sense, but it would certainly be affected by you wouldn't have to meet that obligation if you have a force majeure clause covering war. You can't be aiding and abetting the enemy. Presumably a Canadian military contractor who needs airplanes is building something that could be used against us. So that's kind of an extreme example, but the kinds of things that, you may not even need a force majeure clause to get out of that one, but it's good to have. So I mentioned previously, example, oil and gas leases. I just wanted to provide some of the case law language that has been used for these kinds of things. So the analysis when examining oil and gas leases should take into account that they stand entirely on an entirely different basis from other leasehold agreements. The reasons for that are as follows. It is a highly technical industry. It has a distinct terminology. And here you can look, you don't have to look at necessarily the Webster's dictionary definition of the terms in the contract. You want to look at the party's intent and the known practices of the industry. So you want to look at how they use the terms. So that would apply to a force majeure. So if they list a number of these kind of general events that would be completely unforeseen, I think that you have to look at them through the lens of the industry. So that's one of the reasons that I was using the hydraulic fracturing issue is that, and there's, New York is actually a huge energy state. So these kind of energy leases, oil and gas leases, they'll contain this kind of terminology that requires a more nuanced analysis. So, but if you want any more information on that, just contact me afterwards. I'm happy to provide it. But that's kind of just a glimpse into how these are kind of treated differently. Although they are leases and they often contain force majeure clauses, courts treat them a little bit differently. So here's an example of how a labor dispute, we anticipate with unions and management constantly going at it, how can we possibly not anticipate that there could be a labor dispute? And here's a case. An example is actually the NHL lockout for all you hockey fans. And I pulled a case that has to do with my beloved New York Islanders. I'm a huge New York Islanders fan, and I was very pleased that I was able to use this case. And it's Bouchard Transport versus New York Islanders Hockey Club. And this was a lease agreement between plaintiff lessee, defendant lessor, and it contained a force majeure clause, which would excuse the Islanders' performance, which I normally can't excuse because anyway. But by cause or causes beyond the lessor's control, which shall include without limitation all labor disputes. So when the NHL locked out the players, that's not the Islanders' fault. They didn't make that decision. That's a labor dispute. And the court actually held that there was a specific provision within that contract defining a labor dispute as a force majeure, and they contracted with that. It was not ambiguous at all. So they were able to excuse their performance. There's no hockey being played, and it relieved them of their obligations to pay. So I think that is a pretty interesting example. I think, it can apply to all sorts of different areas. Sports and entertainment. It's not just oil and gas leases and all that exciting stuff, but it can also apply to sports and entertainment. And if none of you remember, sports and entertainment was something we used to enjoy approximately 2 months ago. And hopefully we'll enjoy before 2025. So next thing I want to take a look at is government regulations. Again, this is an example, and it's McElroy Court versus Metallurg. It's First Department case from Manhattan, I guess. Force majeure clause in this case, there was a force majeure clause including what they called plant shutdown. They actually put that terminology in their force majeure clause. So in this case, though, the plaintiff shut down its plant voluntarily due to financial considerations brought about by environmental regulations. So the plan is alleging that the government has regulated them into the ground and they can't operate this plant. It's not feasible. They're trying to save some sort of, this is speculation. They're trying to save some sort of rare bird. And as a result, this plant is not allowed to operate because of regulations put in place by the government. The court determined here that that is not a force majeure event. A government action that causes financial hardship is not grounds for avoiding performance under the contract. These environmental regulations existed when they entered into the contract, which I think is significant. Plaintiff was fully aware of the environmental regulations and the Environmental Protection Agency's intent to enforce them fully prior to entering into the contract with defendant. So here, you can't enter into a contract to do something knowing that it's going to be difficult because of environmental regulations, and then that comes true, and you claim that the environmental regulations are the reason that you had to stop operating, and then claim government regulation, force majeure. It's not going to fly. You were aware of the conditions. People that operate power plants know exactly what the EPA rules are, so they can go right up to the edge. They know what they're doing. And here, the fact that the plant closed voluntarily, that's a decision some businesses have to make. It's not a force majeure event. Okay. So here's an example, another example of government regulation, which is different than the last one, and it has to do with gambling. So Burnside 7-Eleven LLC versus Nassau Off-Track Betting Corp. So here we have a plaintiff is the owner landlord, and the defendant is the tenant and is a regional off-track betting corporation. So the lease provides that the defendant was to use and occupy the premises for any legalized betting and ancillary uses. So this lease did have a force majeure clause, which included government action or inaction. I'm not sure what the inaction portion of it applies to, but here the government action, right? So there was a building ordinance from the town of Hempstead, which is on Long Island, and it was amended to restrict the location of off-track betting parlors. And where it was restricting the location of off-track betting parlors was exactly where this off-track betting parlor was located and where it had agreed to use and occupy these premises. And in this case, because the zoning ordinance took place after they signed the lease, and it was actually an amendment to an existing zoning ordinance, the force majeure defense was successful. They were relieved of their obligations. And that's important because can you imagine being a commercial tenant, not being able to operate at all, but being on the hook for whatever the term of that lease was. So, and maybe they were able to move to a different town and continue operating and continue, betting on horses and all that fun stuff because, they had a proper force majeure clause. And if they hadn't, it's important to contract for these things. So here's another example, illness. It kind of touches on what we're dealing with now. But I'll go through this a little quick. Plaintiff, whose name is Belgium and is also from Belgium, so it sounds like the country of Belgium is suing, but it's not. But Lofraco Belgium contracted with a music service for an artist known as Akon to perform at a concert in Brussels. Had a force majeure clause which said non-performance. It stated Akon's inability to perform due to sickness or accident would be considered force majeure. So this is kind of very narrowly tailored to this singer, and so he would not be subject to liability, though he wouldn't be able to keep the money that he was paid, but he would not have to perform his obligations if he's sick or he had an accident that prevented him from singing. So people aren't going to pay to come watch him stand on stage and wave and all that kind of stuff if he can't do what they're there to see him to do. So that is a very narrowly tailored non-performance in a force majeure. This case actually couldn't be decided on summary judgment because there wasn't adequate proof of Akon's illness, but it does indicate that had he been able to support the defense, it would have been a successful one. So now we're going to turn to the final topic here, which is force majeure clauses in the current pandemic. So force majeure during a pandemic, is pandemic or epidemic contained in the force majeure clause? Hopefully it is for all you business owners out there right now. So here was the force majeure clause in a case titled Touche Ross versus Manufacturers Hanover Trust Company. Force majeure was defined in the contract to include flood, epidemics, earthquake, war, cases which are generally accepted by international practice as force majeure. So here, people are like, well, it says epidemic, not pandemic. You could try to split hairs on that, but a pandemic is just a global epidemic. So I think that if you really did very light digging on the definitions of those, you could get an epidemic clause to cover a pandemic, unless you have a judge who's really insistent that, it should have been narrowly tailored to global epidemics, not just epidemics. So like I said, epidemic versus pandemic. An epidemic is and this might have relevance to some force majeure clauses you folks might be looking at now, where it only says epidemic. So it's a widespread occurrence of an infectious disease in a community at a particular time. I think that you could argue that the global community is a community and it's being affected. So a pandemic is an epidemic of disease that is spread across a large region, for instance, multiple. The terms matter, but here, even if your clause says epidemic, I think you can make a credible argument. So COVID-19, the reason that force majeure clauses are in vogue at the moment, it's having a huge effect on businesses all over the world, and certainly here in New York, where we're kind of the hotspot for COVID-19. And we know that we're shut down for at least through May 15th, I think was Governor Cuomo's last update. So leases, contracts, insurance policies need to be examined for the language contained in their force majeure clauses. The government can suspend certain payments, stop evictions, things like that during this, but eventually that's not always going to be the case. And those things are not permanent. So you need to look at the clauses in your contracts. Even if a contract doesn't contemplate a pandemic or epidemic, check out the language in the catch-all provision. It might be applicable. I don't think the courts will ever be as sympathetic to these kinds of arguments as they are right now, because of they're shut down themselves. They're just starting to conduct Zoom calls with litigants. So, I think right now they're probably as sympathetic as they're ever going to be, these types of clauses and catch-alls. Considerations of the coronavirus. It's unforeseen, especially if the contract was entered into prior to this outbreak. If you're entering into a contract now and you want to invoke, like I said, the epidemic clause, I think you should still have one for the event of a future epidemic. But I don't think I should make the caveat here that I don't think you should think that you can claim that COVID-19 is an unforeseen event, because obviously it's going on right now. You can't turn on a TV, radio, or open a newspaper without that being the main topic. That it's going on. Attempts to perform under the contract despite the outbreak. It depends on what the contract asks you to do. If it asks you to operate a standing room only concert hall, you're not allowed to do that. But if your contract says that you're supposed to be writing short stories, I don't know that COVID-19 would present the kind of force majeure, justification to get out of that. You have, as long as you have the ability to, read, write, and think, you could probably write the short stories, especially if that's your profession. So, another thing you want to look at is essential versus non-essential. If the government has classified you as non-essential and you have a force majeure clause, that could be the kind. You don't expect a government to tell you that what you do for a living is not essential and that you have to stop doing it. I think that there's a very credible argument that a government regulation clause would apply there. So what do you do if you don't have a force majeure clause? There's still other potential options for defense. We've had some questions about them because there is significant overlap. So in practicability, you can try to negotiate with the person you have a contract with, try to get through this because maybe you don't want to break the contract. Impossibility, illegality, frustration of purpose. Okay, and that is the end of my presentation on kind of the generalities of force majeure clauses. If you want any further discussion, I'm always happy to chat, and I actually have more free time than I normally do. So feel free to send me an email. And now I'll cover any I'll try to cover any other questions that you have.
One other question that came up, Eric, was whether there's any implied force majeure clauses and what to do when those aren't explicitly in the four corners of the contract.
So implied force majeure clauses, I mean, that kind of belies contract law, right? You can't really have an implied provision. I mean, you can have provisions that don't say force majeure, but for example, it says in the event of some sort of government shutdown, I know law firms that service the federal government, for example, when they have budget shortages or the budget doesn't pass, and then a firm that services government employees, let's say, those government employees don't have any ability to pay. So that firm might have to furlough some of its federal employment lawyers. So, you know, those kinds of things could be built into your contract or into your handbook, even if you don't have a force majeure. What was the second question?
That was it.
That was it. Okay.
And just as a reminder to everyone, the course code, we did type it into the chat box, but it's the word contract. So please include that on your form. And I think we're just about out of time. But thank you again, Eric, to presenting. I think this was really informative and very topical for this time. Quick thank you again to our sponsors, AXA Advisors, Chicago Title, Council Press, Fine Law, Jack W. Hunt and Associates, and Precision Resolution Paramount Settlement Planning. A reminder, in case anyone is interested, we're doing another CLE on COVID interruption insurance. Steve Pieper from Hurwitz and Fine is going to be presenting. That's on May 7th, and it starts at 9 a.m. It's a 1-hour CLE, and it's free for all UB Law alumni and Erie County Bar Association members. So you can register for that coming soon online. And thank you again, Eric, for presenting.
Sure. Thank you, everyone.